Good afternoon, everyone. I welcome you all to the webinar Anatomy of IBC Cases 2. Today, we shall discuss 6 cases relating to IBC. So, the first session will be till 4:30 p.m. and the same shall be taken by Mr. Sujoy Datta. The next session will be taken by Mr. Ravi Prakash Ganti. So, due to some issues, he will not be able to take session from 4:30 p.m. He will be taking the session from 5:30 p.m. So, there will be a gap of 1 hour. Mr. Sujoy Datta will take following 3 NCLAT cases, that is Dolphin Windtrade Private Limited versus Ashray Vyapar Private Limited and others. Second is Sandeep Datta versus State Bank of India. And third is CA Rita Gupta versus Messrs Shilpi Cable Technologies Limited. So let me briefly provide you introduction of Mr. Sujoy. Mr. Sujoy is an advocate on record with the Supreme Court of India and has extensive experience in advising and representing domestic and international clients in a wide gamut of civil and commercial litigations, including suits for recovery, suits for damages, suits for injunction and declaration arising out of bank guarantees, letters of credits, suits relating to recognition and enforcement of foreign decrees, etc. He has also represented clients in domestic and international commercial arbitrations and ancillary court proceedings arising out of Arbitration and Conciliation Act 1996. Mr. Sujoy also has experience of advising and representing clients in matters arising out of Companies Act, foreign exchange laws, prevention of money laundering, tender matters, and writs concerning public laws, debt recovery, and insolvency laws. Sujoy has appeared before the Supreme Court, High Court, and trial court across India and tribunals, including National Company Law Tribunal and National Company Law Appellate Tribunal. He is also a regular speaker in conferences and web and seminars. So you may now start the session.
Thank you, Anu. Thank you for the introduction. So I'm very happy to be addressing this session today. It is one of critical importance, and in fact, I had an opportunity to discuss the topic for today with my colleagues, Mr. Satwinder Singh and Mr. NTS Chawla. With them, I've appeared in several of our knowledge enhancement sessions organized by the ICSI. I think as important as the contents of any judgments for us as professionals, be it in our interpretation of the law or in our essaying of arguments before the tribunal, most important is the art of reading and analyzing a judgment. So before we get on to the contents of the 3 important decisions that we're discussing today, I would like to give an introduction about the structure and anatomy of any judgment. What do we understand by the doctrine of precedent? How is it that we can find the difference between the doctrine of stare decisis versus res judicata? What is it that we mean when we look at a judgment and we say that this portion of it is its ratio while the other portion is the obiter? What part will be binding and what part will not? These are certain important concepts. We'll go into them briefly and then we'll apply them in the context of the 3 decisions that we are discussing today. So let me put on screen the brief PowerPoint presentation that I've prepared. I trust it is visible, Anu. Okay, let me know if the PowerPoint presentation is not visible. So beginning with the structure of any judgment. When we look at a judgment, it is very important for us to know exactly what it is that we are reading. For instance, very often in one's career, one finds that we go through a judgment and we feel that it lays down a particular law. But upon a closer examination, you might find that in a lengthy judgment, that would merely be an extraction of the submissions by one of the sides of the party, one of the parties, and it would not actually be the reasoning or the finding held by the court. So the way that a judgment is generally divided is, one, it will go into the chief foundational facts from which the controversy arises, following which it will record the submissions of the parties through their counsels, generally the appellant or the petitioner or the plaintiff, and then the counterparty. Thereafter, issues of fact or law are identified. This is a step that is often omitted in many judgments. However, it's a critical part of any civil trial, even in summary process, such as the Insolvency and Bankruptcy Code. An issue is essentially either a position of fact or position of law, which the party approaching the court must establish in order to get the relief that it has come for, and which the opposite party must controvert. So, when any position of fact or law is stated to be true by one party but denied by the other, that becomes an issue of fact or law. So, the identification of issues is an important part of any judgment. It is something that we must do when we are going through a judgment, irrespective of whether the Honorable Court has laid down issues or not. Generally, you would find relevant portions of the statute also extracted, following which you will have the analysis and the final decision. It's very important always to distinguish submissions and findings. Wherever you find in a judgment that it is recorded that in seriatim the following submissions were made, you must keep a track of where the submissions end and where the findings actually begin. Now, why is it that we are looking today at these three NCLAT judgments? And why is it generally that a court will always look towards what are the previous decisions of other courts on the subject at hand or the particular issue raised before the court? As we know, in all common law jurisdictions, and in fact, in almost all structuralized jurisprudential schools all around the world, there is one source of law which is given by the parliament, and the other primary source of law is what is called the judge-made law. So, in all established jurisprudential systems, previous decisions have become an important source of law for a judge to decide any particular case. This principle emerges from the doctrine of stare decisis, which is a Latin phrase meaning to stand in line with the things already decided, to stand with what you have decided. This is the doctrine which creates an obligation upon the court that you must look to the precedent and look to the conduct of other courts on this particular issue when you are deciding any disputed fact or issue of law. It is not a binding mandatory obligation because every case ultimately turns on its own facts, but the principle of stare decisis says that even if there is any difference in the facts, if a particular legal finding, a legal conclusion, or even a rationale can be extracted from a previous judgment, then it cannot simply be ignored. Either it must be applied or it must be distinguished on the basis of facts, or it must be overruled. And naturally, it can only be overruled by a court of greater strength than the court that has passed the previous judgment. So, we understand by stare decisis that a court will always apply the law that is previously laid down. However, as I'm sure all of us know, even amongst judgments of different months in a year on the Insolvency and Bankruptcy Code, you can have different points of view and different decisions on the same issue by different benches. And that is an aspect that has been recognized even by the Supreme Court of India in the celebrated landmark judgment of Rupa Ashok Hurra, in which it was said that the role of the judiciary merely to interpret and declare the law was the concept of a bygone age. It is no more open to debate as it is fairly settled that courts can mold and lay down the law, formulating principles and guidelines. In recent years, there is a discernible shift in the approach of the final courts in favor of rendering justice on the facts presented before them without abrogating but bypassing the principle of finality of the judgment. So essentially, over the years, the doctrine of stare decisis has become more of a guiding principle than a binding rule. It is important always to remember that stare decisis is different from res judicata. As we know, Section 11 of the Code of Civil Procedure prescribes the concept of res judicata. This means that if the same parties have been litigating upon the same or substantially the same matter and issue before a competent court, and that competent court has decided the matter on merits, then the same issue cannot be agitated by those parties between them in a subsequent court. So the difference between res judicata and stare decisis is that res judicata would only apply between the same parties, whereas stare decisis applies irrespective of parties, irrespective of the facts. It applies only on the concept of law. Hence, it is stare decisis that we rely upon when we argue a particular matter and we call upon the court to place reliance upon any previously decided case law. Now, one important issue that always arises is whether a certain portion of a case law is its ratio or is whether it is merely obiter. And we will see this problem when we go through the three judgments that we are discussing today. The issue is that ratio decidendi means the reason or the rationale for a decision. It is the basis, the logic, the analysis of law or facts on the base of which the decision has been given either in favor of one party or in the favor of the other. It is the essential elements of a judgment which creates a binding precedent. Hence, if a particular issue is decided by a court of law, for example, as it was done in the early days of the IBC, whether the period of 7 days for curing of a defect in a petition filed is mandatory or binding. This was settled by the Supreme Court in the J.K. Jute Mills case. It is a celebrated landmark decision. We are all aware of it. In that case, what would be the ratio? The ratio would be something that has the pure element of law removed from the facts. So the ratio would be that the timelines prescribed for removal of defects are directory and not binding. This ratio, the reason why I have cited this example is to show you that it does not matter what were the facts in which a ratio was given. The only thing that matters is what was the reason or the law or the logic which was developed. And this ratio becomes a precedent. Of course, the facts, if you can match your case to the facts of J.K. Jute Mills, then excellent. But that does not matter. The ratio is something, it's a pure abstraction of law which you can apply from one case to another. On the screen, I've extracted the finding from a landmark judgment on the interpretation of ratio decidendi. I'll invite your attention to the second paragraph especially. Finding ratio decidendi is not a mechanical process, but an art which one gradually acquires through practice. What is really involved in finding ratio decidendi of a case is the process of abstraction. Ratio decidendi is a term used in contrast to obiter dictum, which is not necessarily binding in law. So, since we understand what is ratio decidendi, let us look at what is obiter dictum. Obiter means other things that are said in a judgment. So, obiter dictum would be those remarks or observations which can be observations on fact, it can be even observations on law, which, while they form a part of a judgment, are not really part of the decision of the court on the questions that were presented before it. To cite an example, if it is decided in a particular case that, let us take the example of J.K. Jute Mills again, that the timelines prescribed for curing of a defect are not mandatory, they are directory. And it is also, while this was a chief question and controversy before the court, it is also noted by them that a petition for financial debt can be filed in respect of debt owed to any other entity and not just the petitioner. Since this second conclusion or this second remark was not the chief question in controversy before the court, it can't really be said that this is a position of law decided by the court in that judgment. That will not be the ratio, that will merely be an obiter, since it did not answer the specific question put before the court. The principle behind reducing the binding value of obiter is because it is assumed that the court could only give the best of its attention to the particular question that was raised before it, and any answer given in respect of other questions which are not in controversy before the court would not have obtained the full benefit of a detailed consideration by the court, and hence ought not to be taken to have binding value. A popular test laid down in foreign jurisdictions is the Bambaugh inversion test, which encourages you to ask whether the decision would have been different had the statement been omitted. If so, the statement is crucial and would form part of the ratio. And if had it been removed, the judgment would still have gone in the same direction, then it is not crucial and it would merely be obiter dicta. So I've once again extracted a landmark decision on the meaning of the phrase obiter dictum. It is a mere saying, by the way, a chance remark which is not binding on the future courts, though it may be respected according to the reputation of the judge, the eminence of the court, and the circumstances in which it came to be pronounced. The reason for not regarding an obiter dictum as binding is that it was probably made without a full consideration of the case on the point, and that is very broad in its terms. It was probably made without a full consideration of all consequences that may follow from it, or the judge may not have expressed a concluded opinion. With this, I will now come to the judgments that we have to discuss. Before that, I would like to open the floor briefly for questions on the concepts that we've just discussed. These are concepts that have evolved from common law jurisprudence over hundreds and hundreds years of judgments laid down by the court, and these form the basis about why previous court decisions are binding. So if there are any questions, we can discuss them. If not, we'll proceed. So coming now to the judgment of Dolphin Windtrade Private Limited versus Ashray Vyapar Private Limited and another. This is now a very interesting judgment, and it is a judgment that is very heavy on facts. So I've extracted the facts for you on screen, and I would just like to very quickly, I do not wish for you to read along. I will tell you what are the critical facts forming the background, and then we can appreciate the ratio in context of the facts. So in this particular case, there is an entity, the corporate debtor, which has been in financial doldrums since the 1980s. It filed a reference under Section 15 of the SICA in 1986. In 1988, in 1991, it was declared as a Sikh industrial company under the SICA, the Sikh Industrial Companies Act. The BIFER then forwarded its opinion and it recommended for a winding up. An appeal was filed, but ultimately it was dismissed. There were four main lenders, the Indian Bank and certain other banks, and they had filed their debt recovery petitions before suits before the debt recovery tribunal against the company, and they acquired certificates. They acquired decrees in their favor. There was Indian Bank, Allahabad Bank, and they all acquired decrees. The total amount of these four entities was coming to be around 50 crores. The total debt exposure to these four entities by the corporate debtor. Thereafter, in 1997, during the pendency of the SICA reference, a binding up petition was filed under Section 433, 434 of the 1956 Act. This was company petition number 355 of 1997, and it was filed before the Calcutta High Court. The Calcutta High Court in these proceedings found that there was reason to order for winding up, and it directed winding up of the corporate debtor. A liquidator was appointed and he took over the assets of the corporate debtor. Now, in the meantime, the other important party enters the story at this point. In 2007, Ashray Vyapar Private Limited, which was respondent number 1 before the NCLAT, was incorporated and obtained assignment of the debt from all four banks: the Union Bank, Indian Bank, Allahabad Bank, and IDBI Bank. After it acquired the debt, it was noticed that for 50 crores worth of debt, it had only paid a consideration of around 9 crores. And that fact becomes important later in the judgment because the entire assignment was found to be suspicious and dubious, and it was not given credence by the NCLT, and one of the reasons was that it was acquired for an amount which was extremely low compared to the actual debt exposure. So while these proceedings were pending and several applications have been filed by different creditors in the company petition and the winding up proceedings were ongoing, the Calcutta High Court allowed an application filed by Ashray, that is the entity which had acquired the debt. In that application, Ashray had called for a special meeting of all creditors of the company. Now, this was appealed before the division bench, and the division bench said that Ashray, as a bystander or a passerby, cannot be allowed to hijack the assets of the company by convening an illegal meeting. The division bench further directed that the applicant seems to be someone who is a bit suspicious. He has acquired the entire debt for only 9 crores, and there is no reason to give him the weightage and importance. And he, in the case that he files any other application or he tries to seek any similar orders, then this order of the division bench must be given to the notice of the court. So if the applicant again in the future approaches any other court, then he must inform them that, look, the Calcutta High Court division bench had previously dismissed my application in an appeal and it had passed this order. This order was confirmed by the Supreme Court even. The SLP was dismissed. Thereafter, the company petition, the winding up petition, was dismissed for want of prosecution. After the company petition ended, Ashray immediately filed a Section 7 financial debt petition before the NCLT Kolkata. After this petition was filed, the winding up petition was revived because the party approached the court that, see, we had been unable to appear because of such and such reasons. Please revive the proceedings. And the petition stood revived. So now, in effect, there were two proceedings. One was the winding up petition before the High Court in relation to the same company. And the second was the Section 7 filed under the IBC. Now, you will recall that at that time, there was a notification saying that proceedings ongoing before the High Court can be transferred to the NCLT, the proceedings of this nature. An application was filed by Ashray calling for the transfer of the winding up petition to NCLT Kolkata. Ultimately, what happened was that several of the parties which were there in the High Court filed intervention applications in the NCLT proceedings. They filed an application saying that, look, this party has mischievously approached the court. It has not disclosed to the court the order of the division bench of the Kolkata High Court. And the entire petition that has been filed is malified. It ought to be rejected. It is barred by limitation, etc., etc. They did not want a parallel proceeding. They did not want IBC to start because the winding up proceeding had already gained some or the other momentum. However, on the 31st of January 2022, the adjudicating authority, that is the NCLT Kolkata, rejected the application filed by the interveners, the objectioners, and it admitted the petition filed by the respondent number 1, that is Ashray, under Section 7, claiming to be a financial creditor. And then the appeal came before the NCLT. So these are the facts which provide the background and the context for the issues framed, the arguments advanced, and the judgment delivered. Now, the issues that arose in this particular judgment was, firstly, whether Ashray, as a financial creditor, had suppressed and concealed material facts from the NCLT. Now, you will see that this is a question of fact. And I will encourage you to think what will be the question of law or what will be the ratio that will emerge from it. So if I can just ask all of you to think that, okay, whether Ashray suppressed certain critical facts from the NCLT and whether the petition ought to be dismissed. If that is the question, then that's a question specific to this case. But what would be the ratio that you derive from this judgment, which you can apply to any case? And that's a question. You can all jot it down or you can make a mental note of it. We'll come back to it and we'll try and extract the ratio of this ratio on this particular question at the end of our discussion of this judgment. Whether the second issue was whether the appellant has the locus to intervene before the learned NCLT and file the present appeal. Because it is neither a financial creditor nor is it the corporate debtor, does third party have any right to challenge the maintainability of a Section 7 petition? And finally, of course, whether the debts due were barred by time. If they were barred by time, then naturally the petition must fail. We'll skip over the relevant provisions. These are ones that we are all aware of. Coming now to the observations on the first issue. Now, while the court noticed in para 16 of the judgment that while the petitioner had filed the initial judgment of the single bench of the Calcutta High Court, which had allowed its application calling for a special meeting of all creditors, it suppressed the division bench. So it is clearly a sharp practice, and it is clearly very poor conduct on the part of any litigant to file an order, but not to disclose that this order has been reversed in appeal, and not to file the appellate order. So this fact was noticed, and it was also seen that the other order by the High Court, dated 14th of July 2014, where the assignments were observed to be as dubious, were also not placed before the NCLT. So where they had noticed that against 50 crores, only a payment of 9 crores has been paid and all 4 debts have been acquired, and they said that it appears prima facie to be somewhat suspicious, that order was also not placed before the court. What was held by the court on this ground was, we are thus satisfied that respondent number 1 is guilty of suppression of material facts and relevant orders before the adjudicating authority, and the submission of the learned counsel for the appellant is correct, that the suppression was made with motive to obtain an admission order to somehow grab the assets of the corporate debtor. So now when we are looking at the conclusion on issue number 1, you have before you the judgment on screen. I've extracted this one paragraph. This is really the decision. What is the ratio that you can, what is the statement that you can extract from this, which can be applied to any and all case, irrespective of its facts? Would anybody like to try and share the ratio? If not, then I'll take a try. I'll do my best.
So is this observation which we can see on the screen, is it not case specific, because this is about separation of material facts in a particular case?
That's very correct, and that is exactly the point, because what is done here is very specific to the material facts of this particular case. So how to apply it to a future case? How to extract the one sentence or the principle from it, which can be applied without the facts to any future case. That's the exercise that I would like us to try. So would you like to try? What will be the one sentence that you can take out from this one concept of law, which can be applied to any other judgment?
So probably, I mean, if I can make a statement out of it, is that if any party to a suit, I mean, if any party to any proceedings suppresses the material facts in order to obtain a relevant, or rather favorable order from the adjudicating authority, so that would stand. So what does it grab the assets of the with the motive to obtain an admission order? So. I mean, I can say that's a violation of the law. Particular provision can be quoted. Sir.
Brilliant. Thank you so much, Nitin. That's a brilliant response. You've correctly abstracted the law from the maze of the facts. So you're very right. The ratio in this case would be that if any party seeks to initiate insolvency proceeding on the strength of material suppression, then that is a ground for the petition to be rejected. And see, this is a very important point of law, because Section 7, Section 9 of the IBC merely say that, if debt is there, if the default is there, then you must admit. They don't speak about suppression of fact. So this is a concept developed by the court by interpretation in this particular judgment. But this is now a part of the law. So while Section 7 and Section 9 do not say any such thing, now the court has added by a source of law, saying that if a party files a petition on the strength of suppression of material facts in order to in order to initiate CRP proceeding in a malified manner, then on this ground also the petition can be rejected. So that's the issue. So thanks, Nitin.
Sir, I was also thinking it's a basic principle of law that whosoever comes to the court of law should come with clean hands. So, I
True.
mean, if these are the facts of the case, then the person is obviously not with clean hands. So, relief cannot be granted to such a party. So that if we can apply that rule also to this case.
True. And in fact, the principle that you quoted, it's a oft quoted principle. It's a classic principle that one must not obtain the pure stream or the pure fountain of justice with polluted hands. Generally, that is applied to jurisdictions of equity, such as writ jurisdiction. In generally in writ matters, that you can't approach the extraordinary jurisdiction of the court if you have yourself approached the court with dirty hands. But it is good to see that now it is being applied even to purely commercial and commercial matters. Very clear-cut matters like insolvency and bankruptcy code. Generally, commercial laws such as IBC, such as the various SEBI regulations, such as FEMA, etc., they don't really have any scope for principles of equity. But it is clear that that principle of equity has been imported into this judgment and into this otherwise, very clinical area of law. So coming now to the second issue, that is the locus of the appellant. In this, now the objection sought to be raised by the petitioner was that, see, what is to be considered by the court is whether I am a financial creditor, whether the debt is pending, and nothing else. It can't go into any other objections raised by third parties who are neither bank, who are neither the corporate debtor. What is their role before the court, and why ought the court to entertain their objections? So, and on this, what was said was, the appellant by IA number so and so has brought to the notice of the adjudicating authority the orders passed by the company judge in company petition number 355, which was the winding up petition, which were not brought before the NCLT by the respondent number 1. The copy of the orders dated such and such have been filed, which were relevant orders to be considered by adjudicating authority before deciding section 7. We are thus of the view that the appellant has locus to file IA as well as this appeal challenging the impugned order. The objection raised by the respondent number 1 regarding the locus of the appellant is overruled. Now, in my analysis of this particular paragraph, what I feel is that why the third party was allowed to raise these submissions before the court has not been answered. How and why it had the jurisdiction to come before the court has not been answered. Instead, it has been said that they've placed upon record certain valuable orders. These orders ought to have been placed by the petitioner. These orders are relevant because they have supplied us with relevant material. Hence, we do not wish to get into the question regarding their locus, and the objection regarding locus is overruled. For this reason, I would not rely upon this judgment on this ground in a future case. I would not say that this forms part of the ratio, because to me, there is not really a decision of a point of law, but rather it is entirely a decision on facts that, yes, the document given by them is so important that we'll not get into the question of locus. We'll overrule that objection and we'll allow these documents to be taken on record. Coming now to the third issue, whether the application was barred by limitation. On this, we'll see that the date of default, which was mentioned in the application, was 19th of December 2019, which was very cleverly put there because that was the date when the company petition, the winding up petition, was dismissed. But the court got into the issue that how can a cause of action be said to arise for filing of a financial debt petition when the triggering event is merely the dismissal of a winding up petition. See, you might get a cause of action to file a section 7 financial debt petition when the debt is defaulted, when the demand notice is given to, giving 15 days to pay and 15 days pass and you have not yet repaid the bank. But the dismissal of a binding a petition cannot give rise to any cause of action of filing a Section 7 application. And how it gave rise to this cause of action, the petitioner has not even tried to explain. And in this matter, in fact, in 1990s only, the DRT had given decrees to several of the banks. So clearly the cause of action, the default, had arisen a long time ago and was not really something which is happening in 2019, as was sought to be done, was sought to be shown in the petition. I've extracted the relevant paragraph. The application under Section 7 by respondent number 1 does not indicate as to on what basis it can claim that it has right to file an application under Section 7 on 18th of February 2020. As observed above, the date of default of debt fell due mentioned in the application as 19 December 2019 is wholly fictitious and incorrect. The said date has no relevance with regard to debt falling due on 19 December 2019. That is the date when company petition was dismissed in default, which order also came to an end in February 2020 when company petition was revived. The application was highly barred by time, and in the entire application, there is no explanation as to how the limitation for filing the application is there till 18th of February 2020. So ultimately, on these grounds, what the NCLAT held was that there has clearly been rampant suppression of material fact, which was important to be placed before the NCLT, and the debt was heavily barred by time, and thus they held, we are thus satisfied that adjudicating authority has committed error in admitting Section 7 application without adverting to the question as to whether the debt as claimed was due when Section 7 application was filed. The question of limitation of an application has to be gone into the court even though no defense has been taken by the respondent. And on that ground, the appeal was allowed. Now, there was one more aspect of it. We'll come to that. Before that, I would just like to point out to you once again that here in paragraph 30, clearly a ratio is given. That even, and perhaps somebody would like to find out the ratio here. And by ratio, I mean one, conclusion on law, which is applicable in this judgment and in all judgments in the future. If not, I'll go ahead and share it with you.
I want to say that the ratio of this case is that if there is a debt is due, okay, and the limitation period, question of limitation of application has to be gone because the starting of limitation period from the date of application or question of petition.
So yes, you're moving in the right direction, Rajendraji. The ratio has to do with limitation. And essentially, what the ratio would be is completely removed from the fact. The ratio is that the question of limitation can be considered by a court, even if nobody has taken it as a defense. So suppose if I file
suo motu action, suo motu court can take a note without any.
Yes. So question of jurisdiction, question of a limitation, these are threshold issues which can be considered by a court, even if no party had specifically taken them as a defense. So I think that's an important point of law that emerges from this judgment. Now, coming forward, one more aspect of the law which was clarified in this judgment was that irrespective of the existence of a binding of petition, Section 7 application can still be filed. So, and that is something that was decided by a previous judgment called A. Naveen Chandra Steel versus Shree Equipment Finance Private Limited. I've put the citation on screen. However, now the NCLAT held that while that is a correct principle of law, in this case, they will still be in. So the principle given in Naveen Chandra is that, see, even if a binding of petition is lying there, you can still file a Section 7 application. In this case, the court in the judgment that we're discussing, the NCLAT rejected the Section 7 petition and said that the binding of petition is already lying there before the High Court. So why this difference? Why did the court not follow the principle given in A. Naveen Chandra? If we look at the second paragraph put on screen, the Honorable NCLAT held that though the judicial position is clear that Section 7 is independent and pendency of binding a petition does not affect the admission of Section 7 application, the learned adjudicating authority ought to have adverted to various orders passed by the company judge, which has relevance and consequence on Section 7 application. So now the doctrine of stare decisis, if strictly applied, would compel the court to say that, see, the mere pendency of the company petition before the High Court has no impact on this NCLT proceeding. But one of the escape routes from stare decisis is to distinguish the facts. And that is what the court has done here now. They said that in this particular case, the orders which are passed by the High Court are relevant even for consideration in the Section 7 petition. And hence they can't be ignored. And hence these two proceedings can't be held to be totally independent and separate. And the pendency of the High Court proceeding will have to be considered by the NCLT even. So this goes back to the point that we had discussed some 10-15 minutes ago when we were looking at stare decisis, that now the principle has become more like a guiding principle and not a binding rule. And depending on the facts, the court can deliver justice as it deems fit, and it doesn't have to bind itself to any principle given before, if it can distinguish the facts of this case and the previous case. And ultimately, the appeal was allowed. The order commencing CRP was dismissed, and the costs of 10 lakh rupees were also levied, and that was to be paid to the official liquidator. So that's the conclusion of the first case that we were discussing today. Any questions on this? We'll take it up before we go on to the next two judgments. If not, we'll carry on. So the next judgment is Sudeep Dutta versus State Bank of India. And these are actually two connected judgments. There are two impugned orders. Now this judgment deals with personal insolvency. As we are aware, Section 95, 96 are somewhat controversial. They prescribe a particular mechanism to be followed in respect of insolvency of personal guarantors in personal insolvency matters. The constitutional validity of these provisions is still to be decided. It's before the Supreme Court. In some of the appeals, a stay order has been given. In some orders, in some appeals, stay order has not been given. As we know, before we get to the facts of this case, sections 95, 96, up till section 100, 101, prescribe a particular flow, a particular flow to be followed. Upon the filing of a petition against an individual who's a personal guarantor, a personal insolvency petition, immediately upon filing, there is an interim moratorium. And this moratorium is of a slightly different nature than the moratorium under section 14 of the IBC. After the petition is filed, moratorium is passed. The moratorium automatically comes into effect. What the adjudicating authority is supposed to do is appoint a resolution professional. Then the resolution professional will take into account all the material available before it, and it will give a report on its opinion about whether the petition ought to be admitted or rejected. Then, by considering its opinion, the opinion of the resolution professional, the NCLT will either admit or reject the petition. Now, this is a bit controversial because some have said that this delegates away the judicial function. It seems that the judicial function of deciding, of applying the judicial mind to see whether the petition has merit or not, has been delegated from the judiciary, from the judicial authority, that is the adjudicating authority, to a private person, that is the propose a resolution professional. And that is something which is giving cause for concern. Second is, do I have a right to be heard before the resolution professional, before he comes up with his report? Once his report is filed, do I have a right to be heard against the report? And do I have a right to be heard at the stage when the petition is filed, even before the resolution professional is appointed? Can I say that, look, in my case, the resolution professional also ought not to be appointed? And if I don't have these rights, then are the principles of natural justice being trampled? Because no action can be taken against any party without giving them a chance to be heard. So these are the questions that emerge when we read sections 95 to 101. These are the questions being adjudicated before the Supreme Court. And some of them also were at play in the particular judgment that we are reading now, Sudeep Datta. So now with that context, let's come to the actual judgment. The judgment arises from two appeals filed against two separate orders connected in the same petition. The first appeal was passed against the order dated 3rd of August 2021 by the NCLT Kolkata bench, appointing a certain person as the resolution professional and directing him to make recommendation and to submit his report, as we discussed. While this appeal was filed, no stay order was passed. And in the pendency of this appeal, the gentleman gave his report, and the NCLT also started the CRP proceeding, and they admitted the application. And against that order, the second appeal has been filed. The second appeal, 80 Insolvency number 740, is filed against order dated 16th of June, passed in same company petition, where the learned AE has admitted the application against the personal guarantor. Now, these two appeals are being decided together. The question here was that in 2015, the person in question, the appellant, was a director and he executed a deed of guarantee. In 2018, a recall notice was given in respect of the loan, and thus the principal borrower, the corporate debtor, went into default, and of course the personal guarantor also went into default. Shortly after, 3 months after, the appellant, the personal guarantor or the director, the guarantor in question, acquired citizenship of a foreign country, of Singapore. And after that, 2 years after that, this application was filed. The question raised by the appellant was that whether I would be now subject to these proceedings when I'm not a person a resident in India anymore. I'm a person resident abroad. Would the IBC apply extraterritorially to me? And there were other issues. So we'll read the issues one by one. Whether the adjudicating authority has erroneously returned finding of default and it was not permissible in view of the judgment of the tribunal in Ravi Ajit Kulkarni. This first issue, I'll explain this issue once because it's an important one. In the judgment of Ravi Ajit Kulkarni, this was a previous judgment of the NCLT, we'll discuss it once. A certain mechanism was devised that at the time that you are referring the matter to the resolution professional for him to form his report, at that time you can't enter into a finding about whether there's a default or not. So if the NCLT, while it is saying to the RP that, okay, Mr. Resolution Professional, this application has come, I want you to prepare a report on your recommendation of whether the matter ought to be admitted or rejected. And in my opinion, there's a default. Then that is not permissible, because then what will the RP decide? The NCLT, by reaching a preliminary finding by saying that, there is a default, at the stage that it is sending the matter to the RP, prejudices the mind of the RP, and it comes into the stage of deciding default, which ought to come only after the report is actually submitted. So that's a premature decision. This is the ratio given in Ravi Ajit Kulkarni. So one of the issues in this case was whether, while referring the matter to the resolution professional, the NCLT held that there's a default, and thus the judgment of Ravi Ajit Kulkarni was violated. And you see again the question of stare decisis come, that the previous decision, the ratio of that judgment was not followed here, hence the judgment was bad in law. Second issue was whether the personal guarantee shall be extinguished when the gentleman becomes a citizen of Singapore, and whether the proceedings under IBC could have been, even if the personal guarantee does not extinguish, whether proceedings under IBC would lie when the gentleman has become a foreign citizen and thus has gone beyond the jurisdiction of the NCLT. And if it is to be done, then whether the government of India would have to enter into some kind of an arrangement with the government of Singapore in terms of section 234 and 235 of the code. So now let's deal with these issues one by one. We'll not look at the relevant provisions; they're fairly self-explanatory. Let's recap the judgment of Ravi Ajit Kulkarni, because we can't discuss this judgment without discussing two judgments, Lalit Kumar Jain and Ravi Ajit Kulkarni. So first, the judgment of Lalit Kumar Jain versus Union of India was a judgment by the Honorable Supreme Court of India, and there they considered the constitutional validity of the notification by which certain parts of the personal insolvency mechanism were put into force by the central government. So part of the IBC was notified, and it was discussed in para 81 that the method adopted by the central government of bringing into force different provisions of IBC at different times has a specific design, and that design is intended to fulfill the objectives of the code having regard to its priorities. And the objective of the amendment in section 60 was to ensure that the adjudicating body dealing with the insolvency of corporate debtors has before it all the other insolvency proceedings related to such corporate debtors. So in Lalit Kumar Jain, essentially it was said that the personal guarantee provisions, the personal insolvency provisions have been correctly invoked. The judiciary cannot interfere into that. The central government has notified it as per the objectives of the IBC, and that is something which is not arbitrary, it's not unconstitutional. Now, in Ravi Ajit Kulkarni, the judgment of Lalit Kumar Jain was discussed, and a point of law was settled. Before the stage of appointment of the resolution professional, the code or rules and regulations do not provide for any hearing to be given to the debtor. Undertone of section 97 is to bind AA to appoint a resolution professional as nominated by the board. Thus, once application is filed, the next step is to appoint the resolution professional, and by implication, the guarantor in question, the person, does not have a right to be heard before the resolution professional is appointed. Considering the judgment of the Honorable Supreme Court in the matter of Swiss ribbons, it appears to us that keeping principles of natural justice in view, a limited notice of the application should be given to the personal guarantors. This limited notice has to be only to secure the presence of the personal guarantors. Before appointment of the RP, no hearing is contemplated, and before appointment of the RP, the debtor cannot be allowed to raise dispute, for which the correct stage is section 100. However, limited notice may be given to the personal guarantor so that when the RP is appointed, he may provide material as per section 99 and help the RP in collecting necessary evidence. So while you don't have a right to be heard before the resolution professional is appointed, you can be given notice, and the notice is for the purpose that you can come before the court, you can be aware who the RP is, and when the RP is forming his opinion, his report, then you can give to him whatever material you wish to give, so that your point of view is also taken into consideration. Now, this is important. It was an error on the part of the adjudicating authority to observe in para 10 and hold that there is a default when the matter was at the stage of acting on the application under section 97. According to us, the stage for considering whether there was default would be when the matter is taken up under section 100 after the report has come. The appellant is right when the appellant submits that if the AA gives a finding in advance when it is sending the matter to the RP, then the report under section 99 cannot be in the negative. It will be prejudiced, it will be impacted by the judgment, by the decision already given. Now, in our judgment, the one that we are discussing, the para 7, I've extracted it on screen, said the applicant has clearly brought it out in its application coupled with admissible evidence that the personal guarantor has committed default in making payment of cash credit facility. So what the appellant sought to say was, see, in this paragraph, the NCLT has said that there is a default. And because they've said that there's a default, this is premature it couldn't have done so at the stage of sending the matter to the RP for forming of a report. And for this reason also, my appeal ought to be allowed. Would anyone like to venture an opinion? Do you feel that NCLT decided that there's a default in para 7? Is it a correct reading of para 7 to say that the NCLT in para 7 has already decided, prematurely it has decided that personal guarantor has committed default?
Apparently, yes, because they are saying that from the evidence, admissible evidence. It is a preliminary. They have decided that there is a default. That is my opinion.
I share your opinion that the way that the sentence is framed, the applicant has clearly brought it out in its application, coupled with admissible evidence that the personal guarantor has committed default. Generally it seems that the court has agreed with the applicant, but what was decided in this case was something contrary. What the court said was that in para 7 of the judgment, the AA only noticed the contents of the application. What has been noticed is that the applicant has clearly brought it out in its application that personal guarantor has committed default. The said para cannot be read as recording any finding by the tribunal regarding default. Para 7 of the impugned judgment thus has to be read only to the effect that said para contains the averments of the applicant and not the opinion of the court. So very well, if that's the interpretation given by the NCLT, then the controversy gets settled, and the mind of the RP will also be free of prejudice because paragraph 7 has been interpreted in such a manner by the appellate tribunal. And hence the first issue was decided against the appellate, and it was said that the principle of Ravi Ajit Kulkarni has been followed. There is no error in the order appointing the resolution professional, and no grounds have been made to interfere with the said order. First issue was decided against the appellant. Now coming to the second issue, the second and third issue are really connected. All remaining three issues are connected. When a person acquires foreign citizenship, does A, their liability under a corporate guarantee end? B, if the liability under the personal guarantee does not end, then can an IBC mechanism be used? And C, to use this IBC mechanism, would the government of India have to enter into an agreement with that particular country, or can it be done even without such an agreement? So what was held by the court on this ground was that there is no indication in the statutory scheme that a personal guarantor who has given guarantee to a corporate debtor can escape from his liability under the guarantee deed only for the reason that he has, after execution of the guarantee deed, obtained citizenship of a foreign country. Honorable Supreme Court in the matter of Lalit Kumar Jain had occasion to consider the provision of section 2E of the IBA code and has laid down that insolvency process against the personal guarantors to corporate debtors are to be considered by the same forum, that is the NCLT. So if the corporate debtor is already before the NCLT, then that NCLT has the jurisdiction to go against the personal guarantors, no matter where they are. They can be in a different state before the jurisdiction of a different NCLT, or they can even be abroad. There is nothing in the statute that shows that in such a case, simply because the person has become a foreign citizen or a foreign resident, they cannot be proceeded against under the IBC. The key word in section 234 of the code is in relation to assets or property of the corporate debtor, including a personal guarantor situated at any place in a country outside India. So the applicability of section 234, which requires that an arrangement be entered into between the government, the applicability of this section, excuse me, apologies. So the applicability of such a section would only be where the assets or the property of the personal guarantor are situated in a country outside of India. Because naturally, then to attach those assets or to take those assets into custody, you would need to have some arrangement with that foreign country. But in the present case, where the gentleman, while he has become a foreign citizen, all his assets and everything is lying in India, he is very much subject to the jurisdiction of the court. And present is not a case where CRP has been initiated with regard to any of the assets which are situated outside the country. Hence, reliance on section 234, 235 are misplaced. The net result of the above discussion is that the deed of guarantee still continues to be binding, and the guarantor cannot escape his obligation merely on the fact that he has obtained citizenship of Singapore with effect from 18th of June 2018. The statutory scheme of the code does not contain any indication that the personal guarantor can escape from its liability under the personal guarantee deed merely on the ground that he has now started residing in another country and has acquired citizenship of another country and is no more an Indian citizen. It is well settled principle of statutory interpretation that such interpretation of a statute should be adopted, which makes the statute functional and does not make a statute non-functional. The submission of Sri Mukherjee that AA has acted beyond the scope of the code and its action is ultra vires cannot be accepted. The AA is well within its jurisdiction to initiate insolvency resolution process against the appellant, the personal guarantor, in accordance with section 95, and hence the appeal was dismissed. So, in this manner, all the issues were answered. There are several binding ratios that have emerged. It has reaffirmed the ratio of Ravi Ajit Kulkarni. It has reaffirmed that one cannot simply be held to be free from their guarantee obligations because they've switched citizenship. Not only that, even the IBC is applicable if the person's assets are situated in India, only when the person's assets are situated abroad. In order to exercise jurisdiction with respect to those foreign assets, you would have to enter into an agreement with that foreign jurisdiction. But otherwise, you're very much entitled to file an IBC petition and the IBC provisions will be applicable. So any questions in respect of this judgment before we move on to the third judgment?
Sir, it is a well-established principle that the guarantor's liability is coexist the moreover. Why all these doubts arise? Because once the principle that does default is established, why so many questions? It's all irrelevant, I think.
True, sir. I do agree with you that, and you know, from the eyes of the banking industry, it is very troubling that, you know, you have all the documents on paper, the personal guarantor has committed himself to honor the guarantee. And under the Contract Act, the liability of a personal guarantor is coextensive with the liability of the principal borrower. So if the principal borrower has already been found to be in default, all of that, or that bridge has been crossed, then why do we again need to reinvent the wheel and, you know, get into all these questions when we are trying to involve the personal guarantor? And the only reason is that while the same questions cannot be re-agitated by the personal guarantor about whether the debt is a financial debt, you know, all of that has already been decided. Some questions are generally always raised by the guarantor about whether my guarantee continues to be binding or whether it was discharged by variation. You know, sometimes when a bank will give a term loan, then after that they will enter into a consortium agreement. So when they entered into the consortium agreement, they changed the repayment terms, they changed the terms on which the money applied would go into the different accounts. And I, as a guarantor, did not agree to all of that. So that's a novation, that's a discharge by variation, and I ought to be released from my liability. Sometimes they enter into a master restructuring agreement, and on that ground, parties claim novation of contract. So that is why, unfortunately, it seems that, you know, guarantors will always have a few arguments to raise. It can be unfortunate or it can be fortunate. Sometimes genuinely they've been released. So those questions will always, I guess, keep coming.
But my humble submission is, sir, actually, see, in both NCLT and NCLATs are tribunals. They are not expected to function like regular courts. They are supposed to conclude their arguments quickly and go ahead. But unfortunately, both these forums are supposed to be tribunals are functioning worse than the normal courts.
So yes, I will not go so far as to express an opinion on that, but certainly, sir, the issue is being felt by all stakeholders, by the tribunals, the members, the government, and by litigants and advocates and professionals. In fact, I personally am arguing a few matters where the judgment has been reserved twice before two different benches. Then the bench, one of the members has retired, then a special bench is constituted. Then that hears the matter, then one of the members there retires. So yes, definitely the functioning of tribunals leaves a lot of scope for improvement. Even in recent cases of Roger Matthews and Madras Bar Association versus Union of India recently, when the tribunal rules had come out, the Supreme Court had noticed that the recommendations made for functioning of tribunals given in L. Chandra Kumar in 1997, if I remember correctly, has still not been implemented till date. So unless that action is taken, then yes, certainly the functioning of tribunals, it leaves a lot of room for improvement. So coming now to one more judgment, this is not the third judgment that we are supposed to discuss today. It's just a judgment that I want to briefly put before you. The citation will naturally be circulated to all members. This is Satyan Kasturi versus State Bank. This is NCLAT Chennai. And the reason why I mention it today is because this is also very similar to the Sudeep Datta judgment, though it is not as detailed as the Sudeep Datta judgment. Here, the appellant had taken an argument that he is now an Australian national and he cannot guarantee an Indian debt without prior permission from the RBI in terms of Regulation 3A of the Foreign Exchange Management Guarantee Regulations. So he stated that, since I have the provisions are applicable to me, I had to first take a permission from RBI. Since that is not done, then my guarantee obligation itself is invalid. It is against the law and it cannot be enforced by any court. It was held that the respondent bank in this case has proved the debt and default. The default is more than the minimum amount required. And the person is well within the limitation, and the debt is well within the limitation period. So hence, if the critical elements as required under the law are all met, then such a ground cannot be taken. The personal guarantor has entered appearance before the AA, resting upon the Indian address, and as such, the appellant cannot take a contradictory stand in violation of the Insolvency and Bankruptcy Code, which is a complete code. The tribunal holds that the appellant cannot wriggle out of his liability under the guarantee deed, and this foreign residence argument was rejected. So this is a judgment that supports Sudeep Datta, though it is not as detailed, just putting it out for your reference. So we can move now to the third judgment. The third judgment is CA Rita Gupta versus Messrs. Shilpi Cable Technologies. Now, this is another case where the facts are very interesting. The appellant in question is a resolution professional. She was appointed for the corporate debtor in 2017, and the adjudicating authority directed that the fees of the RP should be decided by the CUC. The CUC later replaced the appellant by another person as the RP. And despite the directions given by the adjudicating authority, the CUC did not decide the fees. Hence, the RP had to file an application before the adjudicating authority, and the NCLT vide an order directed the CUC to consider and pay the fees and expenses of the appellant within 2 weeks. Even then, there was some further controversy. The CUC fixed a meeting to discuss the fee of the appellant, and they gave a very short notice, in which time the person was not able to attend the meeting. And whereas the person had claimed a per month fee of 10 lakhs, the CUC approved the fee at what the appellant claims was an arbitrary sum of rupees 40,000. And the out-of-pocket expenses were also fixed at 45,000. Now, the RP was aggrieved. She said that this is an arbitrary fixation of fees. And after that, she was also receiving recovery letters from the CUC saying that, you have withdrawn more fees than we have approved. So you please give back the fees, you give back the expenses. So against all of this, she went to the NCLT. NCLT again directed the CUC to take a reasonable decision. Now, before the reasonable decision could be taken by the CUC, the company went into liquidation, and hence the CUC was no more. They became the stakeholders consultation committee, but they ceased to exercise the powers and authority vested into a particular committee of creditors. So the question now was, who will decide the claim of the contention of the RP that my fee ought to be a larger amount? Is this contention of the RP a claim in terms of the IBC? You know, as stakeholders, operational creditors, they file their claims for such and such amount. Is that the nature of the claim? It was held that no, but we'll come to the finding. And the second question was that whether this will be decided now by the liquidator. Is the liquidator empowered to decide this question because the CUC is no longer in existence? So let's come to the issue. Whether the adjudicating authority was justified in directing the appellant to file her claim before the liquidator as the corporate debtor was under liquidation. Whether the fees of an RP falls under a definition of a claim as defined under the code. Whether the fee of a resolution professional is required to be fixed by COC, failing which such determination is to be made by adjudicating authority under the provisions of section 60. So these were the questions. Now let's come to the decision given. The expression insolvency resolution cost, which provides for the cost of IRP resolution professional cost as defined under regulation 34, have already been discussed at great length by the Supreme Court in previous judgments. The Supreme Court has addressed the issue whether regulation 34 of the IRP regulation, which defines insolvency resolution professional cost and includes the fee of professionals, is a matter to be decided by the NCLT and not by the RP or the COC. The tribunal is of the considered view that the question which arises in this appeal is whether the liquidator has the jurisdiction to decide the fee of the RP, as the COC is no longer in existence. By virtue of section 513E of the code, the fee and expense incurred by the appellant comes under IRP cost, and we are of the view that liquidator cannot adjudicate IRP cost. The COC shall fix the expenses which are incurred by the resolution professional. The word expense includes the fee to be paid to the RP. Viewed from any angle, the fees of an RP cannot be considered to be a claim as defined under section 3 subclause 6. The liquidator can only verify and adjudicate the claim as defined under the code. The amount of fees is determinable by the COC. It is not a claim, and the same cannot be determined or verified by the liquidator. So these are the important conclusions on law. And further they said, we are not going to get into the question of whether the quantum of fees was correct, but we will observe that when the adjudicating authority had directed the COC to reconsider the fees, and in the meantime the company has gone into liquidation, a claim cannot be filed by the RP before the liquidator, and liquidator cannot decide this question, which the COC was supposed to decide. If the COC has vanished, then keeping in view the factual matrix, we are of the view that the adjudicating authority is empowered under section 60 subclause 5 to fix the fee payable to the RP, and it is the adjudicating authority that in such a case would decide the fees. Excuse me. Yes, sorry. So for the aforesaid reasons, we are of the considered view that it is the AA which has to decide fees in the absence of a COC, and the RP cannot be directed to file a claim before the liquidator. Hence, we allow the appeal, the impugned order is set aside, and the matter is remanded back to the learned adjudicating authority. So this was the conclusion in this particular judgment. Number one, the claims, the fees of an RP does not form claim under the IBC. Second, the fee of the RP is something to be which falls within the insolvency resolution process cost, and that is something which only the COC will decide. Thirdly, if the COC is not there, then the NCLT must decide. And finally, the liquidator does not have jurisdiction to decide the fees of the RP. These are the important takeaways. With that, I will conclude on these three judgments. We still have 8 minutes left in our schedule. So if there are any questions on this judgment, we can discuss them.
How much time this last case took to decide to come to a conclusion?
This last case took quite a long time to decide. In fact, you will see that the first order I've extracted is in the facts. The first order of CRP commencement was in 2017, July 2017. And the directions given were in July 2018 for the COC to consider and pay the fees. So from July 2018, we are now, this was decided a few months ago. So around 4 years and several rounds of litigation back and forth.
So even a small issue like RP fees and costs are taking this much time. So what about the larger issues?
That is true. That is true.
In case as regarding the fees that COC is not deciding, and as there is new regulations are there, now these regulations are binding, so that the fees will be as per that schedule only, or again they have to decide again regarding fees payable to the IP.
No, the fees payable to the RP now, IP now has become more clear, but still that scope remains because those are not ultimately binding. Just like the fees of an arbitrator is also not binding, the schedule which is put in the arbitration and conciliation.
This case is the old one, so these regulations will not be applicable.
True. This is an old one. This judgment is, I believe, a few months old now, and but the principles held in it will still hold good. That the cost of CRP will include the fees of an RP. That the CRP cost is something which only the COC can see. Thirdly, when the COC has gone, then the power to be exercised by the COC will not fall to the liquidator, but will fall to the NCLT. Those are the principles of law that will continue to apply.
But suppose the fees of the RP is not paid by the assets of the CD. So who will pay the fees? Is it the COC?
I'm sorry, I lost your voice for a bit. If the fees of
the
the
fees
RP
of
is
the
not,
RP is not paid by the assets of the CD.
Means assets are not sufficient to pay the fees to the RP.
Then who will pay the fees of the RP?
Then the fees of the RP is a lost cause, sir, because in terms of the waterfall mechanism, the first bucket to be filled is the insolvency resolution process cost, and only after that it goes on to the second category where the workmen and secured creditors, etc., come. If the assets are not even sufficient to meet the first bucket, then of course the second bucket will not get any waterfall at all, and in fact even the first bucket may be unfulfilled.
Then is it not the right thing to get the adjudication to get the fees from the COC at the time of the CIR?
Of course, yes, it is. I think all professionals will agree that it is the best practice. It's a clean, it's a good governance practice in CIRP also for the fees to be approved by the COC before any, before so much
not only
time
approved, but not only approved,
but released.
Not released, or even if it is not released, but the direction should be given by the executing authority to get the direction.
But the moot question is that if assets are not there at all, what the liquidator will get.
No, but once you have given you have got the direction, then CSP has to pay. Simple. Whether the assets are equal or not. Because CSP has to decide, that why they are carrying on the CIRP when there are no assets.
But in liquidation also, if there is no asset, then no fees will be paid. The IP has to work as a pro bono and pro bono what?
No, not pro bono, because before the COC gets a penny, it's always the IRP or the liquidator who will get his costs. But yes, it can be imagined that there will be a situation where the assets are so paltry that even the insolvency resolution process costs are not met. In that case, probably the COC will be so disinterested that they will not hold meetings at all. But
That's why I'm saying that is where the RP is able to sense, and you should get a direction to the COC that his fees should be paid by the COC.
True. I agree, sir. RPs
So
are,
that his fees is safe.
yes, I agree, sir. RPs are professionals who put in a lot of effort, and they are often put at physical risk as well. A stronger ecosystem ought to be there for protecting their rights.
There's a voice from Deepak, sir.
Right. So, are there any other questions on these judgments? If not, then we can perhaps conclude our session for today. Thank you. You've been a very patient audience, and I also really appreciated the inputs and the participation that came in. So my contact details are on screen, and I thank you for this opportunity to speak.
Thank you, sir.
Thank you so much, sir, for the session. It was very detailed and helpful. I think one of the key takeaways of the session is that the liquidator does not have the power to decide upon the fees of RP, and the RP fee cannot be a claim filed with liquidator. And also, if the COC is not there, then AA will have the power to decide upon the fees of the resolution professional. Thank you so much, sir, for the session. It was very detailed and helpful. And thank you to all the participants also. So as informed in the beginning of the session, the next session will start at 5:30. So you can end the session or you can keep it as it is.
Okay, thank you.
Thank you, sir. Thank you. Very nice session.
Ma'am, the same link will be
Yes,
activated.
yes, the same link will be used to join it again.
Okay.